This last panel is titled Restoration and Accountability. And I'm delighted that up until now we have had chairs of 4 panels who were virtually exclusively from Duke University. And on this panel we have a chair from our sister institution over in Chapel Hill, the University of North Carolina, Dr. Jerry Postema. And so, Jerry, without further ado, let me turn it over to you.
I got special dispensation from my chancellor to appear here today. It took some bribing, but I was able to do it. The task for this panel is to look forward, but by looking backward in part. One major question, of course, is how is it possible, to what extent is it possible to restore decent civil society in Iraq, to achieve some degree of reconciliation amongst the various groups, and importantly to reconstruct trust, mutual respect, confidence in government, and certain commitment to rule of law in a country that has been devastated by a tyrannical rule for a long time. One important way of getting at that question is to ask how those who have engaged in human rights violations over a long period of time are to be held accountable for them. It's been widely known that there have been massive violations of human rights over a long period of time. But how are the Iraqi people and the rest of us perhaps assisting them to bring some degree of accountability for those actions? To what extent is that important? How is it to be done? What institutions can we draw on? Are there international institutions available to us? To what extent does the American, the U.S., especially the U.S., difficulty with the International Criminal Court raise questions of credibility of the U.S. in this respect? And finally, are there alternatives to criminal prosecution? Is there any room for something like the South African Truth and Reconciliation approach? We're going to be discussing some of them, and our panel, a very distinguished panel indeed, will be discussing them. And what we would like to do is to proceed perhaps at 15 minutes each, perhaps a few minutes less. And then I would like to give the panel a few minutes to talk for us between each other, and then we'll open to the floor to questions. So let me introduce our 4 distinguished panel members. First to speak will be David Malone, who is currently president of International Peace Academy. He's a career foreign service officer. He was educated at let me see. Well, he was educated and made a distinguished career in his education. But since then, he has been involved in many academic institutions: Brookings Institution, University of Toronto, Columbia University, New York University, and the Diplomatic Academy in Vienna. His most recent book is entitled Unilateralism and U.S. Foreign Policy. Early in his career as a foreign service, he served in Egypt, Kuwait, and Jordan. He represented Canada in the UN's Economic and Social Council in the early 1990s. Between 92 and 94, he was ambassador and deputy permanent representative of Canada to the United Nations, where he chaired negotiations of the UN Special Committee on Peacekeeping Operations. Between 94 and 98, he was Director General of Policy, International Organizations, and Global Issues Bureaus of the Canadian Foreign and Trade Ministry. Our second speaker will be Madeline Morris. Madeline, professor of law at Duke University, received her training, I got this one, at Yale in law. Madeline is the director of the Duke Geneva Institute for Transnational Law. She's published widely in international criminal law. She's advisor to the prosecutor for the Special Court of Sierra Leone, and directs the Duke Legal Clinic that provides legal support to that office. She's provided consultation to the United States State Department Office of War Crimes issues, has been advisor on justice to the President of Rwanda, and special consultant to the Secretary of the Army, and co-convener of the Inter-African Cooperation on Truth and Justice Program. Our third speaker is Fiona McKay, who holds degrees from Oxford University and LSE. She is currently director of the Lawyers Committee's International Justice Program. She's done a good deal of work working to strengthen the emerging system of international justice, focusing particularly on ensuring that the International Criminal Court emerges from its birth to become a sound institution. Prior to her current post, she was deputy director of the Kurdish Human Rights Project in London, and before that worked as legal officer for Redress, an London-based NGO that works to promote torture survivors' rights to reparation. And finally, Mark Drumbl, assistant professor in the School of Law at Washington and Lee University. He was trained at Yale University and the University of Toronto and Columbia. He's published widely on issues in international law. He served as public defender in Rwandan genocide trials, taught international law to Afghan lawyers exiled by the Taliban. He is director of Studies International Association of Penal Law, and consults widely. I'd like you to give a good ear to our distinguished panel.
Well, thank you very much. It's great fun to be here. The only thing you really need to know about my education is, sadly, it doesn't include Duke University, which has a terrific law school, so I'm very, very happy to be here today. I also want to pay tribute to Bruce Gentleson, who is one of the leading American academics recognized internationally for work on both peace and security. He takes a hard-headed approach to security as well as a highly committed approach to peace, and is universally well regarded. I'm really happy that this conference has attracted as many students as it has. It's really nice to have students with us, because in effect we're all, it seems to me, studying the Iraq case. We've heard some confident statements at this conference about what the Iraqis may think or want and what the Kurds may think or want. But the truth is, it seems to me, that none of us actually know what the Iraqis are going to want and what the Kurds are going to want. After many, many years of Ba'athist rule by terror, I wonder if the Iraqis themselves today have a clear sense of where they want to take their country. So it's going to be fascinating to follow this in months of all, and we're all going to be students of it. Now, my remarks this morning, I'd like to try to bring to the fore some broad trends at the United Nations that may be relevant to the case of Iraq, talk a bit about transitional justice, touch on Afghanistan, and wind up perhaps saying a few things about the current situation in Iraq. 4 trends at the Security Council I wanted to highlight. The first is that the post-Cold War era at the UN is very different from the Cold War era. The biggest difference is that the permanent 5 members, those with vetoes, by and large, have worked with each other extremely well. There are only three subjects that have divided them seriously. The Israeli-Palestinian dispute, which continues to provoke the occasional American veto, but frankly lacks energy at the UN because the action is essentially dominated by Washington in other fora. Kosovo in 1999 divided the Permanent Five sharply but briefly because there was an agreement amongst them after NATO bypassed the Security Council to bring the Kosovo issue back to the UN after the fighting was over, and to put in place administrative arrangements in Kosovo under the UN's authority, which are still in place. And of course, Iraq has been dividing the Permanent Five on and off since about 1997. For the first 6 years after the coalition action after Desert Storm to expel Saddam Hussein from Kuwait, the Permanent Five broadly agreed on what they should be doing on and in Iraq. But that fell apart subsequently over the issue of regime change, which Madeline Albright first raised as a new American objective, and which in effect provided Saddam Hussein with very little incentive to go on cooperating with UN inspectors. And since then, we've seen the Permanent Five both clashing sharply on Iraq and then trying very hard to paper over their differences and coming together, as they did in Resolution 1441 last November. So the basic agreement of the Permanent Five to address most of the regional conflicts, which were the wreckage of the Cold War, to address a number of new conflicts which have arisen since, is by historical standards quite impressive, with only these three exceptions. Now, from the ability of the Permanent Five have arisen a welter of Security Council decisions, and again, three trends on them I'd like to identify. The first is that having dealt with the wreckage of the Cold War largely, the new conflicts that have arisen have largely been internal conflicts. Mainly internal in their essence. They nearly always involve neighboring countries in one way or another, sometimes a great power or two. They spill over, as the Colombian conflict is spilling over into Ecuador and Peru with the domestic politics of Venezuela, or they can spill in from neighboring countries, for example, in the Democratic Republic of the Congo, where we've had 5 neighboring countries fighting. But in their essence, they're internal, and the Security Council has been willing to tackle them. And Iraq played an important role in that. In 1991, when the fighting had stopped, the Security Council imposed very intrusive measures on Iraq in the human rights field, in the humanitarian field, and of course in the area of weapons of mass destruction. And that willingness to be intrusive in the affairs of a member state had broader consequences over time for other states. Second trend to identify, the council's become much more comfortable with the use of force. And during the Cold War period, it was invoked clearly, really only twice, once in Korea, once in terms of enforcement of the sanctions against southern Rhodesia. Since 1990, and this was introduced by the Council's Resolution 678, on Iraq, there have been many, many instances of force being authorized. It's become, in fact, so routine, resort to the provisions of Chapter 7 of the Charter, that fully a third of the Council's resolutions today are adopted under Chapter 7 of the Charter. This is a major change in international relations that journalists aren't very interested in because it's slow-moving, as are most trends in international relations. The third one I wanted to draw attention to was the return of something I think of as virtual trusteeship. With the end of the colonial era, we all thought that trusteeships were gone, and indeed the Trusteeship Council at the UN became dormant. But with the end of the Cold War and the willingness by the Permanent Five to become both more assertive and more intrusive, we've seen a return of modified trusteeship. First in Namibia, a case of arrested decolonization in the late 1980s, where the UN took over the territory in preparation of its independence. Then in Cambodia, where it shared authority for the country with a rather loose local government. Later in Bosnia and Kosovo, it's too often forgotten that still today in Bosnia, the supreme authority isn't the presidency or the legislature. The supreme authority under the Dayton agreements is the High Representative of the international community, who vetoes legislation and contradicts the presidency. East Timor was another model where the UN took over the territory for 3 years between the violence of 1999 and independence last year. And there are 2 cases pending, it seems to me, of likely virtual trusteeship. One, Iraq, in forms that we don't yet know. We don't know what form this will take over time. And the second is the Palestinian territories, because now the most hopeful route towards an independent Palestinian state would seem to pass through a period of international administration of the territories. I mention these because they're all important. Now, transitional justice, it would be nice to think that there are templates that work in situations like Iraq, but that isn't true. The international community has tried international criminal tribunals. I would argue very successful on the former Yugoslavia so far, somewhat successful on Rwanda. It's trying a modified form of international criminal tribunal in Sierra Leone, and will be trying one in Cambodia. We don't know the outcomes of those yet. We do know that the creation of the 2 international criminal tribunals for Yugoslavia and Rwanda is what lent impetus to the creation of an international criminal court, which could have been useful in Iraq, except that the US is so dead set against the international criminal court. So there's a problem there that some of the other panelists may address. The second approach, broadly adopted by the UN and others, has been truth commissions. Now, truth commissions, I would argue, have been successful in South Africa, in El Salvador, in Guatemala, but they failed spectacularly in other places. Let me mention one case where they failed spectacularly. That's Haiti. And it failed in Haiti because President Aristide wanted the Truth Commission to focus only on his opponents. He didn't want the Truth Commission to focus on the whole truth. And that's a potential risk in Iraq, too. What truth are we actually going to try to look at? Now, in Afghanistan, which is a very interesting case, where the UN resisted American pressure to administer the country as a whole that arose in 2001, the UN helped a form of interim Afghan government emerge at the Bonn Conference in December 2001, identifying Karzai as a leader potentially acceptable to most factions. Karzai, of course, is still in place, buttressed by support from the UN in Kabul. And it's interesting to watch how this is operating. Very slow progress towards elections, much more early action on traditional Afghan modes of consultation of tribal and other leaders in the Loya Jirga. We may or may not have elections next year, we'll see. Justice, frankly, there wasn't much emphasis on justice in Afghanistan. There hasn't been much emphasis on justice. And I think that's because both Karzai and the UN's chief representative there, Lakhdar Brahimi, sense that justice may be more than the fabric of society can bear at this point. Afghanistan's a very fragile country, and justice may need to be postponed there. I would say one thing about justice in Afghanistan. What's going on at Guantanamo can be debated legally in terms of how well it can be justified under American law. Politically, it's been a disaster for the United States, an absolute disaster, because all of the US's protestation of interest in the Geneva Conventions, rule of law, and all the rest appears to be contradicted in its approach to the detainees at Guantanamo. I read in the newspapers that the tribunals are ready to go in Guantanamo. I very much hope so, because this is a black eye the United States can't afford to sustain internationally at a time when it needs to be taking assertive action on justice in other parts of the world. Now, on Iraq, what can be said that's relevant? You had Ambassador Hassouna speak to the conference yesterday, and he said a number of interesting things, I gather, and he's a fine man. The truth is the Arab League is a very weak regional organization. It's been fractured by the crisis over Iraq. It can play virtually no useful role in the crisis in Iraq. And this is different from other parts of the world where regional organizations have been able to play very positive roles. For example, in the Balkans, sometimes in Latin and Central America, and so on. Secondly, the Afghan model of having the UN help to bring about transitional authorities from the country itself could work in Iraq, but Iraq's more complicated than Afghanistan. After the fighting in Afghanistan, the Rump Northern Alliance clearly was the dominant political force in the country. We have no idea what the dominant political force in Iraq is going to be. And so that makes engineering, political engineering in Iraq much more complicated. But I would argue that that model is the most hopeful one for Iraq over time. And the US may come around to that view. The UN, you know, has lots of problems. The Security Council is paralyzed over this issue. It's not a particularly efficient organization in ways that governments, by and large, also aren't particularly efficient. We've recently learned, by the way, that the private sector isn't a model of efficiency in all cases either. But it does carry with it a degree of international legitimacy and credibility. And this will be important for a new Iraqi government, which will be viewed initially with some suspicion by the neighborhood. And so to help reinforce the credibility of that government, it may be useful to associate the UN with it. I think that on that, I will stop because there's so much to discuss in an exchange period, and I look forward to learning from the other panelists. I will say that what the US needs to worry about, not right now, but what they do now is relevant to what they need to worry about, is an exit strategy from Iraq. There's no doubt that a military occupation of the country is not only necessary now, but will need to be quite an extended one. And there will need to be quite a large number of troops there. American troops, British troops, hopefully troops from other countries, to keep the country stable during its transition to new, more hopeful forms of government. But the US has a short attention span. It tends to have an active agenda around the world. It isn't going to want to stick around for a very long time. And the moment of greatest danger for the US is when it wants to pull out 2 or 3 years from now, and how that exit can be managed. And there I'd say the role of the UN, the role of allied governments, the role of Arab partners, dare I say it, is going to be very important. And the US needs to be worrying now about how to help with that transition, allowing for an American exit 2 or 3 years from now. Thank you very much.
I suppose that in terms of scope and I hope not also interest, my presentation will be the very opposite of that, very broad-gauged and extremely well-informed and informative talk that we've just heard. What I'm going to do is to pretty much try to lay out a descriptive diagram, as it were, of the options for prosecution's accountability in post-conflict Iraq, and to try to situate what we know about current decisions and options under consideration within that broader range of overall possibilities. Then I think by laying out sort of that description and that framework placed within the context of the broader issues that you've raised, we'll then be able to go on with what I think will be more normative and analytical evaluations of where we stand. Criminal prosecutions for abuses committed under the current regime in Iraq have been under consideration for many years in the U.S. and elsewhere. The U.S. government, other governments, non-governmental organizations have long been involved in a very systematic and large-scale evidence-gathering effort, so that there's actually quite a bit that's in place, and we're hardly, as you all know, starting from scratch. In that regard, the current conflict, of course, has focused the debate and required a decision point and some specific method for going forward. The question of prosecutions, then, and how to proceed arises in the two different contexts of prosecutions for war crimes committed in the current conflict and the somewhat distinct issue of crimes committed under the Iraqi regime over the past 2 decades prior to the current war. With respect to both of those categories of crimes, there's quite a range of possible methods for prosecution, letting alone other forms of accountability like truth commissions that we will discuss. But there have been quite a range of prosecutorial approaches that have been advocated in the past few months. One has been, well, the very opposite of a prosecutorial approach, that is the discussion of an amnesty for peace arrangement, in which it was contemplated at one time, and quite specifically contemplated by Rumsfeld, that there could be an amnesty arrangement whereby Saddam Hussein and certain members of his inner circle could be allowed to exit the country, go into exile, and in effect receive an amnesty for crimes in return for allowing a war to be averted, a very typical kind of amnesty deal, posing all of the quandaries and dilemmas that trade-off always does pose. Just a footnote to that point, and noting, of course, that seems like a direction we will not be going in. There was some discussion when that was under active consideration that how could we possibly do that even if the United Arab Emirates, which is one country that came forward possibly offering a base for exile. Even if the United Arab Emirates were to agree to an amnesty deal that wouldn't bind other states, how could this be undertaken in a way that would be meaningful? And there I think that in addition to the sort of house arrest model, where the person ends up limited to some territory or territories of states that have offered an amnesty but can't travel elsewhere because of the prosecution that might ensue in a state that had not offered an amnesty under any number of forms of jurisdiction, including universal jurisdiction. I think there's also the possibility of a Security Council Chapter 7-based amnesty. And I heard little discussion of that when the amnesty discussion was going on a month or two ago, and when the objection was raised that you can't have a binding amnesty. You can't have an amnesty that was not binding on all states. It's my view that you could under Chapter 7, though not everybody shares that view. Precisely in the interest of maintaining or restoring international peace and security, the Security Council is empowered to do a wide range of, to issue a wide range of resolutions binding on all states, including, I would submit, an amnesty requirement. But certainly that's not where we're going. Another position that has been advocated, a method of prosecution or form for prosecution that's been advocated and continues to be advocated, would be some form of international tribunal. The International Criminal Court, as David Malone mentioned, arises as an idea. Of course, it could not, in practical terms, be the forum for prosecutions, in part because neither Iraq nor the United States are parties to the ICC treaty, which, under the terms of the treaty, would then mean that the only condition under which the ICC would have jurisdiction would be if the matter were referred by the Security Council, very unlikely given the U.S. veto on the Security Council and the U.S. position on the ICC, and on what will learn about the U.S. position on prosecutions in post-war Iraq. In any case, even then, the jurisdiction, again, under the terms of the ICC treaty, the jurisdiction of that court would go back only to July 1st, 2001, and so would not capture the 2002, sorry, would not capture the foregoing period and the crimes committed during that period. Query whether the Security Council, in referring the case to the ICC, could, if acting under Chapter 7, extend backward the jurisdiction of the ICC. In any case, not likely to happen. And the complementarity provisions of the ICC treaty that gives states priorities in prosecuting also would probably, under the particular circumstances that we see here, make remote the prospect of prosecutions actually going forward in the ICC. Query again whether Chapter 7 action by the Security Council can override the complementarity regime, but in any case, I don't think that those questions will be answered in this particular context. If not the ICC, but still an international tribunal, there would have been the possibility, perhaps, at least there's been the suggestion, not most recently, but within some past years, of creating an ad hoc tribunal for Iraq along the lines of the ad hoc tribunals for the former Yugoslavia and Rwanda, presumably under the Security Council Chapter 7 powers. There was a suggestion even of, more recently, of amending the statutes of those existing ad hoc tribunals to bring within them the events and crimes committed in Iraq. And the U.S. had, under the Clinton administration, pushed quite hard, lobbied for an ad hoc tribunal to be set up for Iraq. And of course, that was unsuccessful. And we don't see any likelihood at this point of an amendment to the ICTYR treaties or another ad hoc tribunal being established. Again, if for no other reason than because that's not what the U.S. plans to do, and the U.S. has the ability, obviously, to influence any Security Council action that would be required to go in the ad hoc tribunal direction. So if not an international tribunal, and leaving, of course, on the table the fact that there are those who still advocate for an international tribunal, and that would be the way to go, but if not that, another possibility that has also been floated would be, apart from a strictly international tribunal, the possibility of a mixed or hybrid tribunal created presumably through some agreement between national authorities in Iraq and the United Nations along the lines of the Special Court for Sierra Leone, which is created precisely as a sui generis entity, as existing by virtue of an agreement between the UN Secretary General and the government of Sierra Leone, with jurisdiction and powers specified strictly within that bilateral agreement. As you well know, a similar possibility has been under consideration for Cambodia. That negotiation has been very, very long and drawn out, and so far not very successful. But the possibility has been floated of a hybrid tribunal, and I think that Mark Drumbl will be talking about that in some greater depth. A tribunal that would be created in cooperation and collaboration between the government of Iraq and the United Nations. Which government of Iraq, who would be the government of Iraq? I presume an occupation or interim government entering into an agreement with the United Nations in order to create a collaborative and hybrid national-international court. Obviously, also, there exists the possibility of prosecutions at the domestic level by an occupation government in Iraq, or prosecutions at the domestic level by a reconstituted Iraqi indigenous judiciary. With all those possibilities extant, within the past few weeks, the situation has clarified around those somewhat. The U.S. has made public some of its decisions and some options under consideration. The intentions of the U.S. government appear to be as follows, and I'll try to lay out what seems to be decided upon as distinct from what's still very much under debate. I'll talk first about what's being considered relative to crimes committed in the current conflict, and then the task of uses separately, because it does seem clear that those two will be treated in distinct ways. For crimes committed in the current war, there exists the three possibilities of trial by court-martial, and/or trial in military commissions, and/or trials in U.S. federal courts. And those options could be used either exclusively, alone, as one sole approach, or in combination with different cases going to different fora, depending on set criteria. In any case, prisoners of war would be entitled to trial by court-martial, consistent with the relevant Geneva Convention provisions that would afford the entitlement of prisoners of war to prosecution under the same conditions as U.S. Service members would be entitled to. That said, one possibility under consideration would be to provide courts-martial for POWs, but trial by military commission for captured individuals determined not to be qualified as POWs. So these unprivileged combatants would be not entitled to POW protections and could be subjected to trial perhaps by military commission rather than court-martial. Now, that bifurcated approach would, of course, require a determination of whether any particular individual were a POW or an unprivileged combatant, a determination made presumably pursuant to Article 5 of the Geneva POW Convention. One question still under consideration then in Washington is whether conducting courts-martial across the board, even for unprivileged combatants, might be preferable to this bifurcated system, in part because it would obviate the need for extensive Article 5 determination and Article 5 tribunals, and for other reasons as well, including the appearance of different treatment and the political implications of the military commission model, as was touched upon by David Malone. However, the U.S., in whatever way the U.S. may decide to proceed with regard to prosecutions for crimes committed in the current conflict, there remains also the open question of the role of the U.K. In such prosecutions. The U.K. could turn over defendants to the U.S. In some cases, for example, if the victims were U.S. nationals, or if for some reason, other reason, there seemed to be a cause for rendering suspects for trial by the U.S. But there, the death penalty issue comes in rather obviously. The question whether the U.K. would be willing to render for trial under U.S. jurisdiction individuals who might be subjected to the death penalty, as would be the case in some of these prosecutions. Beyond the question then of prosecutions for crimes committed in the current conflict, there remains the issue of prosecutions for past abuses. And the U.S. has indicated its intention in that regard that those prosecutions be carried out by Iraqi courts, quote unquote, whatever, leaving of course open the extensive questions of exactly what Iraqi courts are or would be. Those Iraqi courts, consistent with Iraqi law, might include judges from outside of Iraq, particularly the participation of Kuwaiti judges is under discussion, but also the possibility of judges from elsewhere outside of Iraq as well. Certainly the inclusion of Iraqi judges or lawyers who have been in exile, who have been in the Iraqi exile community over the past years and would be returning to Iraq in order to sit in Iraqi courts that would hear these past abuses cases has been widely publicized as an important component of this plan. Obviously, as we start looking at who would sit on these courts, Iraqi, non-Iraqi, Kuwaiti, Iraqi exiles, all of the issues of post-conflict justice start to become very, very obvious. Who sits in judgment on whom, what biases are there, what influences, who's in power, and needless to say, those are central in all of the prosecutorial prospects or possibilities that we're looking at. There's also the possibility of a separate set of prosecutions in Kuwaiti domestic courts, particularly for crimes committed during the invasion of Kuwait. Any prosecutions in Kuwaiti domestic courts or in Iraqi domestic courts presumably would not be collaborative efforts with the UN, or at least again, there would be the blockage of such a collaborative effort because of the death penalty issue. And the death penalty, there's been some pretty serious expression of intention to apply the death penalty, or at least to make the to this set of cases in those domestic courts in Kuwait and Iran. Concerning the prosecutions for past abuses that would take place in Iraqi courts, there's been the concern not only of bias, but much more specifically within that, the criticism has been lodged that those trials wouldn't be authentically Iraqi, but would really be conducted under an interim government presided over by the U.S. Central Command. That criticism is somewhat misplaced, probably not entirely, but the intention seems to be to convene such courts rather later, rather than immediately, so that they could, in some sense, be meaningfully Iraqi once an Iraqi reconstituted judiciary could emerge. That said, fundamental issues remain, as they always do in transitional justice or post-conflict justice situations. Domestic processes are always subject to bias claims because there's a new regime, there's the victors trying to vanquish, almost always. There's the fact that almost nobody in such a society has been untouched on one side or the other, as victim or perpetrator or both. So how can any of these indigenous processes go forward in any way that would be fair or even-handed? The question always arises, and the response always arises, equally forceful, that outside justice imposed from without is lacking in some respects and is not fully satisfactory either. And in any case, typically, principally affected states have been reluctant to relinquish control over prosecutions, and indeed this tension is reflected in the complementarity regime of the ICC treaty that gives states priority in the prosecution of cases. The U.S., as you know, in terms of policy, has, particularly under this administration, has a strong preference for domestic justice processes as opposed to international ones. And we can certainly take up, and I think will take up, this underlying debate in some of these normative issues and political questions that arise with our subsequent speakers and our discussion. So I will conclude there. I hope that I've at least provided a service, if not a enormously fascinating discussion, no analysis, but description at least of, I think, where we stand and what our options might be. Thank you.
So, Madeline Morris has extremely ably set out the landscape here. I'm going to also talk about the question of accountability and about the question of accountability for those bearing greatest responsibility for the most serious atrocities committed going back over the last couple of decades. And it's not because it's the only or even perhaps the most important issue, and I think it's important to remember that there are other challenges, of course, including what to do about people, I think what was referred to yesterday as the debarkification and questions of truth commissions, or interestingly, as I understand it, the idea of what will be called forgiveness commissions, which might be set up in Iraq, and I hope that we can come back to some of those really important issues in the discussion. As Madeline said, the human rights crimes of the Saddam Hussein's regime are very well documented. There's an enormous amount of documentation available, evidence that could be put before any court that's going to try people. I'm going to just very briefly touch on why accountability at this point is important. I'm not going to rehash what will be well-known arguments and reasons. They're very well-known, the reasons why any country emerging from a period of severe repression and conflict might want to undertake such a process. Of course, promoting long-term peace and security, stopping a cycle of violence, etc. But I think there are a couple of particular points it's worth stressing in the Iraqi context. One is the very real fear that if it's not signalled from the outset very strongly that there is an intention to deal with accountability, then there's the very real danger that people are going to take matters into their own hands. That we already saw this in the 1991, after the end of the Second Gulf War. We had people, vengeance killings taking place in Iraq. And so there's the danger that if people don't see a process coming up, even if it's not happening right now, then that could be very dangerous. I think there's also a sense, because in Iraq you have the situation where people who might have been involved in some way in committing these serious crimes are riddled throughout the society. There's a sense that unless you pick out those bearing greatest responsibility and start some process of bringing them to justice, then you'll have a situation where there's perhaps a sense of collective guilt in the whole of society, and that's not a healthy thing. So everybody agrees, it seems, that justice needs to be done, and the question really is how. Madeline Morris outlined the plans that we know about. Pierre Prosper, the US Ambassador at Large for War Crimes, who I understand appeared at this conference last year, but isn't here this time, outlined the US plans earlier this week, in fact. A couple of things that are noticeable about the plans that Pierre Prosper outlined. One, of course, is that there wasn't any mention of the role of the UN, and one of the points that I think is most important is that there really must be a role for the UN, and I'm going to come back to that. Second is that he mentions only the possibility of crimes committed by Iraqis, and there is, of course, the question of crimes committed by others, including in the current conflict. And I'm not going to go into the question of what war crimes might or might not have been committed by US or UK forces in the conflict, but just to stress that there have been allegations raised. The onus, of course, is on the governments of the US and the UK to investigate those in good faith. And I'm not going to talk about the International Criminal Court because, as Madeline Morris said, it's really not realistically going to be relevant in the context of Iraq. But one thing that is likely to come up, because there has been, I know, discussion in the UK on this point, is that it is likely that there will be complaints, communications, or I suppose information, the most neutral way to put it, sent to the new prosecutor of the ICC relating to possible war crimes committed by UK forces, and of course the UK is a party to the ICC statute. So to come back to what Pierre Prosper outlined, I think that to have this dual approach to justice from the outset is unfortunate. To separate out between crimes that are committed by Iraqis against US forces on the one hand, and crimes committed against the Iraqi people on the other. Because, well, first of all, how's this actually going to work in practice? If we imagine that the tribunals, whether they're military commissions or perhaps more likely courts martials that are set up, we can imagine that those would happen more quickly than any process for dealing with past crimes. And while, of course, the US might be entitled to do this, what's really going to happen? Imagine that Saddam Hussein, if he survives and is captured, is tried before some form of tribunal for crimes committed during the current conflict. He's sentenced to a long sentence of imprisonment, perhaps the death penalty. What's going to happen? I mean, once you've had that, once you've been sentenced to death, what is there left to do? And if he isn't sentenced to death, is he then going to be handed over to some kind of to an Iraqi process? And what kind of message does this send to the Iraqis, that they're getting crumbs from the table in terms of justice, that their suffering over the last two decades is less important than crimes that might have been committed during the conflict. And how is this really going to help the US credibility gap that we've been hearing so much about? So what is the best way to bring Saddam Hussein and other senior regime members to justice for these atrocities? Pierre Prosper, as we've heard, spoke of an Iraqi-led process. That's the term he used. And we know that there are detailed plans, as has been mentioned, under this working group, developed by this working group on transitional justice, for having a special chamber of an Iraqi court that would be established by Iraqi legislation to deal with the most serious crimes. Of course, that would take time, and it assumes that you do have an Iraqi power, an Iraqi authority that is able to enact this legislation. Well, I think there are a number of problems with this approach. One, of course, is that Pierre Prosper didn't mention the UN at all. He didn't, I don't think, specifically rule out UN involvement, but he didn't mention UN involvement. And I think for the reasons that Madeline outlined, it's really going to be very difficult for independent, impartial justice to be delivered by the Iraqi legal system anytime soon. And I know that there's a lot of sensitivity on the part of Iraqi exiles, for example, and a number of Iraqi groups saying, do you think that we're not capable of doing it? We don't have the high caliber jurists who can do this. I think that's not the point. I think we know that there are many extremely capable Iraqi lawyers, just as there are around the whole of the Arab world. But that's not the point. The real problem is, and we know this from the experience of the last decade or so, we've got a lot of experience to draw on, that you really can't expect a country emerging from such a dark period and having a considerable amount of political pressures and instability looking into the future to do this kind of thing alone. And I mean, just one point that Madeline raised, that, well, there's the question of the possibility of having a Kuwaiti judge. Well, Kuwait, of course, is a country that's been involved closely. Are we going to have a Kurdish judge also? It's very difficult to imagine how this could really work in practice and give independent and impartial justice. Secondly, there's the problem that, of course, looking back, we're dealing not only with crimes against Iraqis, but also crimes against Iranians and Kuwaitis, and you've got the problem of again, are you going to have a process that involves several different tribunals dealing with different crimes possibly committed by, and some of the same people being indicted before them. Thirdly, I think it is also important that the kind of initiative that seems to be envisaged by the US, this Iraqi-led process, would very much suffer from the problems of legitimacy in the region and in Iraq itself, because it would be viewed, and it is a process so far that's been developed very much under the auspices of the US government. So it wouldn't really be viewed as, it may be an Iraqi, presented as an Iraqi-led process, but it wouldn't actually appear as really an Iraqi process. So I think that it's really important to involve the UN, not down the road on this, but right now. I mean, for the reasons that I mentioned in the beginning, it's really important to send a signal right now that accountability is going to be dealt with. I think that the way it could happen is that the Secretary General could ask, the Security Council could ask the Secretary General to appoint a commission of inquiry to look at a range of issues relating to the scope, jurisdiction of any tribunal. Should it be the Rolls-Royce of tribunals, the ICTY, ICTR model, which of course has certain advantages of funding and Security Council powers to back it up, but seems to be difficult politically at the moment, particularly, of course, not only the US, but a lot of states that have been plowing a lot of money at the moment into building up the new International Criminal Court are not going to be very happy about being asked to put in a considerable amount of money into another international tribunal. So I think the US is not going to be the only obstacle there. Or, of course, the alternative, as we've heard, that there could be some kind of tribunal established by treaty. And again, although that might take some time to actually happen, if the process is starting now at looking at that, then I think it's very important. There are going to be a number of issues there, very sensitive issues. Should a court sit in Iraq or not? I mean, this has, of course, been an issue that's been very important, and there are pros and cons. The Rwanda tribunal has decided not to have it sitting in Rwanda. The Sierra Leone tribunal is now sitting already in Sierra Leone, but that would be something that would need to be looked at. Should it sit in Amman? Should it sit in Baghdad? Should it sit somewhere else? Should it have? I personally believe that any tribunal should operate in Arabic and should have Arab judges, not just Iraqi judges, but from judges from the Arab region. And also that it should draw on Iraqi law as well as international law. I think these are really important factors in the long term, thinking about how such a process is viewed internally in Iraq. It's really important that of course, it can assist in the long-term rebuilding of the Iraqi legal system. It's got to be seen as relevant to the lives of Iraqis. We've learned a lot of lessons from the ad hoc tribunals for Rwanda and former Yugoslavia about how people in those countries don't know about what's happening in those tribunals, don't feel that it's very relevant to them. I think we need to definitely learn those lessons. So, to conclude, I think that really only a process involving the UN can achieve the legitimacy and the effectiveness that is necessary. I think it's really important to start now, not to wait. As we've heard in relation to Afghanistan, there were good reasons for holding off in terms of planning what to do about accountability. I think in the context of Iraq, we shouldn't wait to be looking at this. It should be happening straight away. So,
Well, let me begin by wishing you all good morning. It's always fantastic to be the last speaker on the last panel when we're all hungry for lunch. So, with that in mind, let me begin. Let me first begin by thanking all of you for your unflagging attendance throughout all of this. I'd like to also extend my thanks to Scott and to the Center for involving me in this. It has been, for me, and I feel confident I can speak for all of us, an absolutely fantastic 2 days, a great learning experience. I personally have learned a lot, and I look forward to the opportunity to share with you now some of my thinking on the role of law in political transition, with a specific focus on the obvious task before us, namely thinking about Iraq. Well, let me begin with a series of questions. And this is a series of questions that I've asked before, and I think a series of questions that international lawyers are often not that comfortable thinking about, namely this. What necessarily is the role of law in transition? What good can we achieve by prosecuting systematic human rights abusers? Are the answers to those questions capable of being boilerplated in various different contexts? Or are there limits to what law actually can do? And I think when we think about the Iraqi context, we need to keep those questions in mind. So what I think I would like to do here today is begin by asking, why should we prosecute these systematic human rights abuses? I'd like to offer what I think is a fairly honest version of the traditional arguments invoked by the international legal community in favor of those prosecutions. I'd like then to discuss some of the limitations to the role of law, in part borne out by my own experience in Rwanda, although I, of course, do not mean to make a direct analogy between the Rwandan context and the situation before us, and then conclude, I guess, on a note that I seem to see resonating with many of my colleagues here, namely, there is a role for law, there's room for law, and perhaps a good articulation of that legal voice might be in the Iraqi courts somehow structured, assisted, supported, consolidated, or informed by some type of international legal structure and expertise. So let me begin with the first part, namely, why do we prosecute? Well, traditionally, I think we can evoke 4 or 5 different reasons. One reason is what international lawyers might call the deontological reason, namely, evil is evil, evil needs to be punished. Even if there is no net gain to arise from the punishment of evil, it still needs to be punished, for evil is evil. That's one argument, and I think it carries a lot of moral force. Now, that deontological argument is consolidated, in a sense, by what I would call the consequentialist argument. Namely, we prosecute not just because it's right to prosecute those who commit systematic evil, but because it can do some good. And the good that it can do is, for example, incapacitate those who commit those offenses, or, much more interestingly, serve to build a better society. There's some type of a consequential link between prosecutions and a better society, a society that may be more transparent, a society in which people may feel more comfortable, a society that may be democratizing, a society that may benefit from the rule of law. And I believe there's some force to those arguments as well. Another set of arguments are what I would call the expressive function. Namely, law sends messages. What we deem to be criminal and worthy of punishment is a reflection of what we think collectively and normatively ought to be the way we should live. So when the law punishes these types of abuses, it sends a message. It expresses content. It shows what we think and about the world in which we ought to live. And I think that also is an important function. And I think another function that we attribute to these prosecutions is what I would call the social constructivist function. Namely, by prosecuting, we build not only a better society, but we build what one could call the thinking citizen. Namely, someone who may be more independent in face of governmental authority, someone who may feel him or herself a stakeholder in society, and someone who may be, at a personal level, more willing to resist the types of situations in which mass atrocity occurs. And of course, commonly cited last function is what I would call more of a cathartic function, namely vindication for victims. The victimization levels in many societies, Iraq included, that suffer these types of abuses and for which we're trying to move towards a better place, often need to be addressed and can be addressed to some extent by legal process. Now, all of those sound very good. They're very eloquent, and they move me. I don't know if they move anyone else. To some extent, they move me. But there's limits to them. And I think we need to be very aware of those limits. There's a need for vigilance and care, I think, when we think about the role of law in political transition. And I will go so far as to say that in a perfect world, perhaps trials, criminal trials, can affect all of these goals. In a good world, they may achieve some of them, but let me underscore, they may achieve none. And there may be places and cases and spaces in which they actually undermine some of these goals and may create more friction than necessarily a different type of accountability process may lead to. And I think the linchpin of all this credible, and as one in which they feel included as opposed to excluded. And I think that that is a very important premise with which to begin our consideration of the Iraqi case. And if we go in with this notion that there are limits to law, there is a limit to the role that rule of law can play, and if we're sensitive to those limits, I think we can build more effective institutions on the ground. Now, before I discuss in greater depth what types of legal structures in the criminal trial process may be effective here, which has been very ably, a point already very ably alluded to by my colleagues, let me start with an important caveat. There's a difference between trials and accountability. There are many ways to hold wrongdoers accountable for their wrongdoing. Trials can be one way, but they're not the only way. There are modalities that include truth commissions, public inquiries, often what I would call traditional and often extrajudicial dispute resolution, reparations. There are many ways to secure accountability. Trials are one way in which accountability can be facilitated, but they're not the only one. And I think, and have argued in different contexts, that trials are most effective when coupled with a more holistic package of mechanisms that promote accountability in different ways and through different means. I think it's very important for us to be cognizant of that, and I really hope that in the question period and the discussion that follows this, that we also accord some attention to other ways in which accountability can be secured. Not every victim wants to see his or her abuser prosecuted in some type of Western-style criminal process that may lead to imprisonment. That's just not what everyone wants, and I think it's important for us to realize that. All that said, I think I'd like to make a case here for a limited yet important role for Iraqi courts assisted by United Nations expertise and guidance in the adjudication of a number of captured, and let's not forget this, when we think about who necessarily may appear before a tribunal, we have to assume that that person is alive, A, and B, captured. This is murky. We don't know who's alive. We also don't know who may be captured. David spoke about the ICTY, and clearly there have been trouble in terms of apprehending fugitives. Many have been, not all. So we need to be realistic about this. For those alive and captured, I believe there's room for a UN-assisted process. Let me tell you why. I was heartened, in a sense, to hear the position of Pierre Richard Prosper and the government in terms of thinking that Iraqi courts can play an active role in prosecuting those that have created a terrorized society in Iraq. Yet, I fear that if the situation simply extends to saying Iraqi courts go do this, the problem that arises is one of lack of infrastructure, lack of resources, and let's not forget, lack of credibility. When you live, and I have not, yet maybe some in the audience have, and I'd be eager to hear from you, when one lives in authoritarian, totalitarian societies where there's a deep level of violence, I think it's difficult for people to view judicial or governmental institutions with any level of faith, hope, credibility, or any type of meaningful understanding. And clearly, the Iraqi judicial system is jaundiced in that regard. And also, I think, when we think on the other side of tribunals, Iraqi courts, let's say, funded by the United States, we run an opposite risk, namely that of victor's justice. In other words, if these courts are funded and run like American-style courts, I think we face the opposite credibility problem, namely that of victor's justice. And I think that United Nations-assisted tribunals can serve a bit of a medium between these two opposites and I think can play an intelligent part in attaining the deontological, expressive, consequentialist, and transitional types of goals that international lawyers very demandingly, I think, put on legal process in times of transition. And why do I think so? Let me tell you why. First of all, I think to some extent, an advantage of domestic proceedings is that they can possibly internalize justice, make justice meaningful to local populations. And I think that if the framework involves the Iraqi courts, then we may start with some type of optimism there. Although, of course, I am sensitive to the fact that Iraqis may perceive the domestic legal system as I said before, jaundiced. With some United Nations involvement, and let's not forget, the UN has a lot of expertise in legal matters, a lot of expertise. And although in the past I have been critical of the ad hoc international tribunals in terms of the work they've done, I recognize that they have done a lot of work, and that a lot of it is in fact quite good, and I think it's important to realize that. And my intuition is that there can be a useful transfer of expertise in that particular context. I think another important point is this. We've spoken a lot of reconstruction. We've spoken a lot of the United Nations over the past 2 days. We've spoken a lot of tensions regarding what is the level of UN involvement, if any, in an area that may transcend, for example, simply providing humanitarian assistance. I would argue that this is such a user-friendly area. I would argue that the legal settlement of crimes committed within Iraq by the Ba'ath Party and some of its officials over the past decades is a potentially fertile area where United Nations and international involvement can meet with United States involvement, can bolster local infrastructure and capital, and at all times involve jurists from other Arab countries and those perhaps esteemed in the Muslim legal community. I see this as a point of attraction, a point of settlement. And I think it's important for us to think of law in political transition, not just as law for the sake of law, but law integrated in transition. And in the case of the Iraqi context, this type of integration may serve a second highly political purpose, namely mediating the conflicting goals, in some senses, of the international community, the United States, the UK, the Arab League, in terms of Iraqi reconstruction. And I think that's quite an important point. Thirdly, I would suggest that trials may offer a venue whereby competing claims. We've heard, for example, this morning, differing viewpoints on interethnic divisions, interreligious divisions within Iraq. Whether we agree or not on the exact amplitude of those divisions, I think we can definitely agree that legal process may serve a mechanism in which competing claims can be articulated in a friendly and controlled forum, which is a more effective forum than articulating claims on the streets. And closely tracked with that observation is the following. The Iraqi judicial system is one that doesn't only need to deal with past crimes, but also present crimes. We worry about lawlessness. One way to resolve lawlessness, or at least try to work towards that, is to have a judicial system set up within Iraq, assisted ably by international expertise, that remains within the province of the Iraqis, because eventually that system can do more than a judge past human rights abuses, but also can serve to adjudge present and future crimes. Let me make one more comment why I think international involvement is important. The crimes that took place in Iraq over the past decades are first and foremost crimes by Iraqis against others. They're local crimes in internal conflict. Yes, there have been human rights abuses in Kuwait. I would also add potentially in the Iran-Iraq conflict, but primarily the focus here is on crimes within Iraq committed by Iraqis. But they're not just local crimes. They are, in many senses, and depending on the proofs that can be tendered, also crimes against all of us, because they're crimes against humanity, potentially in certain contexts, and crimes against the world community. Systematic human rights abuses don't just traumatize local populations, they also blight us all of humanity. Hannah Arendt's, for example, celebrated discussion of crimes that took place during World War II. They're not just crimes against local populations. They have a dual capacity. And in that sense, there's some role and benefit, I think, to an international process that is involved, that recognizes that victimization and determinations of guilt and innocence should primarily be local matters, but they have an important international element. So in a nutshell, those are some arguments I believe in favor of some type of UN involvement in hybrid court, whatever you call it, however you structure it, whatever agreements are set up, those are matters for detail, I think, rather than gist. And the gist of what I'd like to convey is that although there are limits to law, there is a role in the Iraqi context, in my mind, for Iraqi courts to proceed through deep and constructive assistance from the international community. Let me make one final comment, and then I will stop. And that is this. Professor Morris talked about the potential proceedings involving crimes committed by Iraqi militia, soldiers, and officials in the ongoing, still ongoing, although tapering off armed conflict between the U.S. and UK and Iraq. Let me say that for those particular crimes, I think it's very important that we be even-handed and careful in how we think about those. Let me add, I think that the moral authority for prosecuting Iraqis for Geneva Convention violations, I think to some extent, has been damaged by the political decision to treat all individuals on Guantanamo as unlawful combatants and not set up Article 5 tribunals, these impartial, competent tribunals that the Geneva Convention mandates to determine who may or who may not be a POW. And I think an argument can be made that soldiers fighting for the Taliban in Afghanistan may actually be entitled to POW status. Now, let me say why this is important. It's important because there's an interconnectivity to law. What we do matters elsewhere when we may be victimized by other people elsewhere doing things wrong. We need to think about precedent. We need to think about how we're perceived elsewhere, and to come full circle. It is the validity and importance of those perceptions that in many ways motivate me here today to be very inclined in favor of proceeding through multilateral, UN-assisted proceedings that remain under the control of Iraq. I thank you for your attention.
Not only is law limited, so is time. And in the interest of time, I beg the forgiveness of my colleagues for contravening our agreement and open the floor immediately to questions, please.
My name is Warren Wickersham. I'm at Duke Columbia and have a lot of interest in international matters involved here on that. I'd like to see if I can get away with a trick that you see the journalists do at the CENTCOM briefings and ask two questions, unrelated, but I'll make them brief. And the first is whether the members of the panel have any view as to how far down the chain of command these cases would or should go, whether there's any norm in the prior situations. Today, I gather the Central Command has issued a 55 most wanted list, and many of those, of course, will be dead or not available. But what types of acts are actionable and how far down the chain. And second, I have no experience at all in Iraq, but for a long time I was the only American lawyer practicing law in the Middle East, and I've been in all the other countries. And the Egyptian lawyers have had historically a great reputation for training other lawyers, for practicing, being called upon to come into Saudi Arabia, Kuwait, the Emirates, and so forth. I didn't hear much mention of that other than by Professor Drumbl at the end about bringing in other respected journalists. And I wonder whether, if the United States is not going to allow UN participation, whether they wouldn't gain a lot of points by saying we would like to avoid Kuwaitis judging the Iraqis and the possible bias there, to bring in someone like the Egyptian panels and so forth from other Arab states.
Who would like to do it? Please.
Well, two interesting questions. First of all, I think on the chain of command issue, one can't be too rigid, because it may be that people quite a long way down the chain of command have committed horrific crimes. So I don't think you'd want to set a template and then be stuck with it. That being said, early signals out of Washington on, for example, the administration of the country suggested that Washington wants to eliminate only the very top tier of different ministries in the country and so on, that there's a concern with getting the country up and running again, which I think is appropriate. So rather than pursuing justice as the very first item of business, to focus very much on vital services to the population, trying to get the existing administration restarted urgently, rather than viewing de-Baathification, for example, as the most urgent item of business. So I think that's relevant and, broadly speaking, appropriate. I think your point about Arab jurists is a very good one. Whatever shape tribunals take in Iraq, I think it would be very wise to include judges from Egypt, possibly Lebanon, which has a fairly admirable judicial tradition also. There's a very fine Egyptian judge of the World Court, Nabil al-Arabi, and this is in line with, it seems to me, traditions in the Arab world. So on both those scores, I think the Arab world will be able to help quite a lot.
On the first point, I won't add anything, but just concur on the second point about the use of judges from elsewhere, particularly Egypt. There's a tradition of that, and that would be useful. On the first point, I think it just raises a huge issue that I think remains to be addressed in all of international criminal justice and transitional justice, which is who gets prosecuted, and that goes directly implicates the questions that Professor Drumbl was discussing, which is what are we trying to accomplish here? And who are we trying to serve? If we're trying to serve victims of the direct and personal victims of the particular atrocities committed, then it may well be that prosecution of some top tier of leaders won't cut it. That just doesn't respond to the needs of victims, the desires of victims. If, on the other hand, what we're trying to do is to serve interests of some of these states really not affected, the other states in the world, or all of the states in the world in deterring future abuses in other places and so on, then it may be that a focus on leaders is perfectly appropriate if we think that, if we follow the logic that without the leaders this wouldn't have happened. That said, without the followers it wouldn't have happened either. And it may be that a cross-section of prosecutions is more effective so that it's clear that nobody is free from the prospect of prosecution, be they leaders, followers, or otherwise, if what we're looking for is some form of deterrence. And I could go on. There's quite an analysis to be done about the question, how low do you go? How many? Is it a cross-section? Is it a top tier? Depending on what we're trying to accomplish, and of course we're trying to accomplish more than one thing. One little further comment on that, which is that it's always been notable to me, remarkable to me, that with all of the resources that have been poured into this whole area, nobody has ever conducted a serious and systematic study of what victims want. And that there's a crying need for that information.
Another question?
Hi, my name is Gerald Cook. I'm a student here at Duke University School of Law. I have first a comment and then a question. Professor Malone, my comment is primarily addressed to you, although it stems from a sort of an assumption, I think, that was characteristic of some of your remarks and some of the remarks in the last panel. And that is that the United States needs, or the Iraqi justice system will need some type of international involvement necessarily for the time when the U.S. implements its exit strategy. In other words, that we need a sort of exit strategy for the follow-on from the current situation. I would imagine that a more realistic assessment of what the U.S. long-term relationship is going to be in Iraq is not going to be either military occupation or absolute withdrawal from the country, but is more likely going to be a prolonged and sort of continuously adjusted pattern of involvement in Iraqi society, something I would imagine similar to the situation that we still have in Germany and Japan today, where after 50 years after the fact, you no longer have certainly occupation forces or even stability forces, but you continue to have American involvement in those societies, and it's an adjusted situation, but it's not one where there's ever full withdrawal. And my question is addressed to Ms. McKay, although several other speakers addressed and talked about this issue as well. It seems to me that there's a disconnect between the assertion that on the one hand we want to build systems, a justice system that is responsive to the needs of justice and responsive to engaging the Iraqi people, and then the assertion on the other hand, therefore we need to involve the UN in this. I think the experience of precisely the Rwanda tribunal and the tribunal in Yugoslavia, in the former Yugoslavia, would in fact argue empirically for precisely the opposite reaction. That those experiences have not involved native jurists and the native population in that system of accountability, and that in fact a far more useful, practical, and probably just solution is the involvement of engagement of persons of that society in a situation like we saw after World War II, where in fact you had the participation of the native, the national jurist systems and lawyers of the victors in working with the populations to implement a system that was responsive to the knowledge and to the traditions and to the experience of the people that were there and involved on the ground. Thank you.
Thank you. Madeline, you want to respond first? Or Fiona, why don't you?
Okay, so respond on that one. Yeah, I mean, I don't think any of us intended to convey the idea that you're talking about either the UN or the Iraqi justice system, or certainly parts of it, in an accountability process. I think it's important to have both. We might have differed somewhere on the scale. I think I would tend to say that the UN should have a greater role than I think Mark seemed to be presenting it. But the important thing, you have to have, I think, you have to have some kind of authority that rises above the fray. That's really the point, because you cannot expect, I think, you cannot expect a country emerging from the kind of dark period that Iraq is emerging from to be in a position to do something like that by itself effectively.
Thank you for there are two very interesting questions. Let me start off with the second question. I don't think that it's fair to use the Rwanda example in a sense as boilerplate for what we're thinking about here. The Rwanda Tribunal is not situated in Rwanda. It has primacy over the domestic Rwandan courts, and I think it represents an early go at this sort of 1990s decade of transitional justice. And I think we've progressed from there to a situation where, to varying degrees, what we seem to be thinking about is more a situation in which the United Nations can offer assistance, whether it's assistance, whether it's support, whether it's a framework. We can all agree to disagree. But I don't think anyone is really suggesting that a tribunal be set up, cited elsewhere, run under the auspices of the United Nations, and have primacy over, well, not just the Iraqi courts, but any foreign national court. Now, I'd like to just make a brief comment on the prior question. This is something that does concern me to some extent, and that is this. I think, although I believe the United Nations still exists as the most articulate voice of legal expertise on these types of transnational matters, and in that sense confers some legitimacy, what I'm more interested in is having expertise, international support, and international jurists than I am having a logo there. And I take, in a sense, pause when I hear commentary, for example, yesterday by Bill Crystal, I think, who, what I think is raised a very important question that I don't really like to hear too much, but it's an important question, namely, what do the average Iraqis think of the United Nations? And might it actually be the case that in light of what could be constructed as United Nations stagnation vis-a-vis the military liberation of Iraq, the concern that I have is if Iraqis do actually feel the way he may, and I think plausibly suggests they do, then we may be better off with just international assistance than organized international assistance under the UN. We need to assess on the ground the level of credibility and legitimacy, and we can't assume it. I believe it's there. I'm prepared to admit I might be wrong.
Well, on that last point, one thing, and then back to my premise, and you're quite right about my premise. On UN stagnation on Iraq, it's interesting how Washington constructs this, because the truth is that the Security Council stagnated when the US stagnated on Iraq. The fact that the UN Security Council was virtually inert on Iraq between 1998 and 2002, in fact corresponds to inertness in Washington on the subject, partly because Clinton was otherwise occupied with Camp David, some of his domestic problems and so on, and partly because the Bush administration had other priorities early on. So once again, we see Washington using the UN as a sort of whipping boy and scapegoat for often its own actions and inactions in places like Rwanda, Somalia, and so on. Now, as to my premise, yes, indeed, I think it's very healthy for the US to think about an exit strategy from Iraq. Because in the Middle East, populations are very sensitive to colonialism. They have lots of experience of it. They seem to be allergic to the presence of foreign militaries. The case of Iran is instructive. In Iran, the American military thought they were up to all sorts of good things, and doubtless they were animated by good intentions. But their presence in Iran greatly fed the impetus of the Iranian Revolution in 1979. So I think it would be healthy for Washington to be planning an exit from Iraq at some point. What that point should be, I don't have a very strong view on. Does this mean that the US has to leave Iraq altogether? Not necessarily. There could be American bases in Iraq, but those bases shouldn't be occupied, it seems to me, with Iraqi politics, internal stability, or administration. I think it is important for Washington to have an end game in mind in Iraq. Otherwise, it will all end in tears for the US as well as for Iraq, in my view.
Yes, please.
Francis Hampson. Obviously, the credibility and legitimacy of any system of accountability depends in part on whether those who are creating the system are also willing to be called to account. And in that context, I'd like to consider the issue of the accountability of the coalition, not with regard to possible war crimes and the fighting that has occurred, but in the immediate post-full-scale war situation. First, there's clearly a need for a genuine and effective complaint system for local Iraqis, and the experience in operations such as Somalia, Rwanda and Kosovo is extremely negative. Some countries have no system at all. Others received complaints but appeared to file them in the waste bin. Others brought proceedings but had derisory sentences such as 2 weeks loss of pay for killing a local child. And bearing in mind here that there's no status of forces agreement between the coalition forces and Iraq, that in the case of the UK, it is taking with it its obligations under the European Convention on Human Rights, which has an individual complaint system, and the UK has conceded in the Bankovic case that where forces are on the ground, that's within the jurisdiction of the European Court of Human Rights. So there's going to come a time when they're not engaged in military operations, but in policing operations, such as manning checkpoints and so on. The UK's experience is that, both as part of a decolonisation process and more recently in Northern Ireland, is that they've learnt the hard way. They've learnt by losing cases, they've learnt by losing politically. And the formula they use is to say that the military are assisting the civil power. They are no longer acting under military authority. The only authority British forces have in Northern Ireland is the same as a policeman. If a killing could not be justified by a policeman, then a serviceman will go to jail for murder. Could you tell me whether the only basis for legal accountability in the case of the United States will be the Uniform Code of Military Justice? Or when they're exercising policing functions outside US territory, could they be accountable under ordinary, non-military United States criminal law? And what are you going to do if the mechanisms you create in Iraq with a proper criminal code choose to detain and bring proceedings against a member of the US Armed Forces when you don't have a status of forces agreement?
I'm still taking notes.
What a terrific question. Good to see you, Francois. The UCMJ is what would apply, I think, is a simple answer. And I would assume that there will be something akin to a status of forces agreement, or at least an agreement that would cover the relevant situation in the setting up of an interim authority and in the setting up of a judicial authority that would have jurisdiction once one comes into existence, that would allocate jurisdiction between the two, that is to say back to the U.S.
Mark, go ahead.
Would they be applying laws that apply to the conduct of military operations, or would they be applying policing kind of laws?
They would be applying UCMJ law, which would include both, which would cover both combat-related and non-combat-related provisions in criminal law.
Mark, do you want to add something to this?
Just one very quick comment. Namely, I completely agree with the overall notion that in order for justice to be legitimate, it must be perceived as even-handed. And I do believe that if there are, for example, let's look at the potential Geneva Convention prosecutions against Iraqis that Pierre Prosper has spoken about, I believe that those, in order credibly to be undertaken, must also be accompanied with legitimate investigation of any credible accusations or allegations of Geneva Convention violations by coalition forces. And I believe it's important to underscore that. So I'm not as familiar with the details of what you ask as Madeline is, but looking at the bigger picture, it's absolutely necessary that there be that level of credible investigation of credible accusations. Yes, so I would agree with you entirely. The spirit of your question, at any event.
I'm afraid I'm going to have to call this session, and regrettably also this conference, with the exception of lunch, to a close. Let me take the opportunity to speak for all of us, to thank my good friend Robinson Everett, Scott Sillum, and Bruce Gentle. Right, sorry. For a wonderful conference, one that was enormously stimulating to me, coming from an area not very well versed in these issues. I've learned an enormous amount, and I want to thank you all. And thank you all also for your patience here today. Let's thank our panel and retire for lunch.